Alexis Haley Hinton, Patience Nicole Lunn, Deja Marie Thomas. In all of this, their names need not be lost when the record is final. Regardless of what transpires today, they are why we are here. Alexis Haley Hinton, Patience Nicole Lunn, and Deja Marie Thomas.
All right. Have Mr. Torres, have you read the pre-sentence report in this case?
No, I haven't.
Counsel, do you know if? Go ahead.
I'm sorry, Judge. It was sent to me. I did talk about it with him, and I talked about the recommendation with him. I didn't send it to him because he was present in your court at the time. And again, I got the call from Ms. Wielding about coming into court. So I wasn't able to send it to him, but I did talk to him about it.
All right. You did discuss it with your attorney.
Oh, there was a notice sent to my attorney from probation officer. And I talked, asked him if he read it. And he read it.
Okay, but did you talk to your attorney about what's contained in the report?
No, I did not.
Okay.
Mr. Torres, the conversation we just had when I got off of Zoom and I spoke with you about what was in the report. Do you remember that?
Yeah, vaguely I did. Yeah, I'm sorry about that. Yeah, I talked to him about it. Yes.
Okay.
Yeah, I'm sorry. I just couldn't.
So you talked about the pre-sentence report?
Yes.
Okay. It's going to be a bit difficult, counsel, because are there any material deletions, corrections, or additions to the report?
I don't see that there are anything that's factually or any deletions or additions that I need. Just disagree with the content of it. That's all.
All right. Go ahead, Ms. Blair.
Yes, Your Honor. I would just like to indicate to the court that the deceased victims' mothers are present and they would like to address the court prior to sentencing.
All right. Very good. Mr. Torres?
Yes.
Have a seat. I want him over in the second seat. Very good. Okay, who do I have here?
Good afternoon, Your Honor. I'm Rochelle Wilson from the Prosecuting Attorney's Office, Victim Advocate. I've been asked to read the statement into the record, but I'll let the victims' mothers introduce themselves for the record.
Yes.
I'm Sherry Smith. I'm Patience and Deja's mother.
All right.
And I'm Christy Green, Alexis's mother.
All right. Very good.
Well, Thomas Pearson, he's giving Patience and Deja's father.
Okay. All right. Very good. All right. Go ahead.
Thank you, Judge. Victim impact statement for the loss of Alexis Hinton and Patience Lunn. Coming up with words for this particular statement was considerably more difficult than we imagined it would be. How do you put a metric or a value on life, on 2 or 3 lives? If we're being honest, it feels like they slipped through the fingers of our society and it's taken us to a dark place. In a perfect world, we would have all the answers. We would know why John Torres was chasing our girls. It would never bring us peace, but we could find a way out of the gloom and the shadows that the unknown tends to cast. It would give us an opportunity to make decisions with all the truths, decide if anger, guilt, acceptance, or perhaps forgiveness was merited. And if all are, in what order? Accidents happen every day, but does he bear responsibility for contributing to what happened on August 2nd, 2021? This is the unfortunate side of perception and how subjective it can be depending on one's viewpoint. The justice system is all about what you can prove, but what happens when the evidence falls short of truths that appear certain? This is what happens. We are in court discussing a case where 2 girls were lost and 1 survivor at the age of 15 who experienced unbelievable trauma, diagnosed with multiple sclerosis at the age of 17, and yet remained alive with a daily reminder of what happened. And we are asking for a mere 60 or 90-day sentence to be upheld for a misdemeanor. If there was an exception to be made to increase that time frame, we would ask the court for it today. Now, we have, as a society, have spoken, and we are vengeful, whether we want to be or not. When terrible things happen to those we love, we inevitably are, regardless of jail time or probation or court related. We want the guilty to experience suffering in some similar fashion or degree as either the victims or their families have, and continue to endure. Now, ordinarily, we wouldn't wish any suffering on any other human being, but pain and adversity can be catalysts for growth. That being said, the number of days served in jail will never balance the scales of what was lost. Their absence in our world has left a void that cannot simply be filled by any sentence. But as big of an injustice as it was not to have a higher severity of charges, it would have been an even greater insult if the max sentence wasn't applied here. Anyone who has been to the crash site can clearly see that the driveway that was used to turn around, which means the carnage of the wreck that was witnessed before the 911 call. While we typically reserve this word for positivity, we hope that those visual images visit the one responsible daily, just as memories visit us. That the regret of one's actions settle into the soul of the guilty and eats away at their conscience. One can only hope that one day, whether it's tomorrow or 10 years from now, that there will be some level of culpability and contrition here. While we can't promise it will be met with understanding and forgiveness, it would reinforce our faith in humanity. Alexis Haley Hinton, Patience Nicole Lunn, Deja Marie Thomas. In all of this, their names need not be lost when the record is final. Regardless of what transpires today, they are why we are here. Alexis Haley Hinton, Patience Nicole Lunn, and Deja Marie Thomas. Thank you, Judge.
Come up to the stand.
Counsel, is there anything you or your client want to say before I do impose sentence?
Yes, if you don't mind, Judge, thank you. And first off, it's not lost on me the fact that there are families there that lost their children. And I've been to your court a couple of times about this case, and the families have been there, and they've been respectful to me, and they've been respectful to Mr. Torres. So I want to make sure I make that clear. And I mean no disrespect in the way that I advocate for my client. I know you know me, Judge, and I know you know that, but I want to make sure they understand that. This is a case where the prosecution themselves dropped the charges on the reckless driving causing death. My client pled to a failing to stop at a property damage accident. And I don't know how else to say this. I don't want it to sound, like there's no empathy in it whatsoever, but there's not a victim to the failing to stop at a property damage accident. The evidence is what it is about what happened that day, and it is sad what happened. It really is. But he's not here because of a reckless driving causing death. He's here because he failed to stop at a property damage accident. And Judge, I'd ask that you sentence him for that. I mean, to ask for jail time, even the recommendation from probation, it just seems, that we're linking two things that aren't linked. I mean, this is not, Mr. Torres never would have entered a plea to something that put him at fault for this accident or responsible for this accident. This isn't the accident we're talking about. The accident that he failed to stop for is the rear end collision that happened when he was struck from behind with the truck. It wasn't failing to stop for the accident that resulted in these girls' death. It wasn't that at all. The plea was based on the accident that happened before that. And so, again, I can't state enough that it was painful to read the police report and to see what happened as well for me, and I feel bad for the families. But Mr. Torres isn't here being sentenced for that, Judge. So I would ask that you sentence him to fines and costs, as you would with a failing to stop in a PD accident.
But counsel, let me just, I understand, I guess, the argument that you make. But as I understand factually here, there's a rear end collision. And whatever the circumstances that transpire in that sort of brief moment, there is then the vehicle that the victims are driving that goes past Mr. Torres. And then there is, as I understand it, there's sort of this high-speed thing that happens. I guess I say that because it seems to me, and one of the concerns that I have with it, and while it may not, I guess, legally fit within the definition of reckless driving causing death, that but for those young ladies feeling that they were chased, the rest of it doesn't happen. Right? I mean, am I missing something here? Because that's the way that I see it, that had, just by way of example, had the rear end collision occurred, Mr. Torres remained where he is, regardless of what the young ladies did, and they leave. If he doesn't go after them, we don't have the rest of it.
And Judge, respectfully, I disagree. I believe that that's the facts that the prosecution, want that they have in their police report. I don't believe that's the facts that the evidence shows. The evidence shows that after they took off at a high rate of speed on their own without him following them. Then he took off, and only evidence they have after that is that somebody says from a camera, it appears that he's also traveling at a high rate of speed. But the evidence also shows that none of the vehicles that saw that truck going down the road where it ultimately, crashed, none of them saw Mr. Torres's vehicle on that road. He said he turned around on that road, but that was when he lost sight of that vehicle. We have an allegation that that he was following them at a high rate of speed, and that's it. But that's after this accident happened, Judge. I mean, that what he pled to was to leaving the scene of the rear end collision. And I don't want to put the blame on anybody in this situation, especially it's such a horrible situation. But I don't think we need to put the blame on anybody for that, Judge, because we're not here to talk about. We're not here to deal with that situation. And I don't think Mr. Torres's actions after the fact did cause or are responsible for that accident. And if they were, I think the prosecution would have at least attempted to prove it. And I don't mean anything negative towards the prosecutor, the way I say it that way. Sometimes when I say things, they come out very, very harsh, and I don't mean that to be that way. I think what we have here is exactly what it is, Judge, an accident. It's an accident. Mr. Torres didn't have any blood, any alcohol or drugs in his system that day. And it wasn't, it was a rear end collision. And I think that they didn't want the cops called on them. And so they took off, and he followed them until he couldn't see him anymore. I don't think that is something that warrants jail.
But counsel, I don't mean to quibble, but certainly in terms of how the court views this, that what I hear you saying, which is different from my impression in reading through the report and everything that I see here, is that the actions, that your client's actions did not cause in any way the victims in this case to do anything. Even if it was, let's say they took off at a high rate of speed, that they continued at that high rate of speed because he was behind them. I mean, what I'm hearing you saying is the fact that your client was there had nothing to do whatsoever with what ultimately occurred.
I don't think that would be an intelligent thing for me to say. You're right, Judge. What I'm saying is, I don't think that the fact that my client decided to follow them after they left the scene doesn't result in them getting in the accident that they got into. The accident, by all accounts, by everybody who saw it, the accident happened when Mr. Torres had already turned around. He was gone already. I mean, it's not that the accident happened because he was chasing them. It's because the accident happened on their own. And
I want it clear as I read it that the car with the young ladies continued to proceed because in the manner it did, because he was behind them. Now, granted that the accident that ultimately occurs may have occurred at a later point, I think it's something different, though. I mean, for me, I want to make sure I have it right, but that's when I look at the report, that's what I see.
And Judge, with all due respect, I don't believe that the report to be evidence in a situation. That was a disputed fact. That's why it was reduced or taken. That's why the reckless driving causing deaths were taken back, is because they couldn't be proven. There is absolutely nothing in the police report about Mr. Torres. Anything that goes beyond Mr. Torres simply following them and then losing sight of them. Anything else is a disputed fact. We would have disputed. We would have taken that to trial. I mean, we ultimately pled because the charge was brought down to reckless driving, and we worked out the agreement to the failure to stop at the PD accident. At no point was this plea ever based upon any actions that were taken after the fact. But even if it were, Judge, those are disputed facts. The fact that they put it in a police report, with all due respect, doesn't make it true. And the fact that the person who wrote the PSI took that information from the police report doesn't make it true. There was a very good argument, very, very strong defense that the things that were in that police report actually were not what happened, based off eyewitnesses who saw the truck on the road before it crashed, based on eyewitnesses who saw Mr. Torres, not on that road at all. And so I dispute those facts. And again, I'm not trying to make something that might appear to be non-complicated complicated, but those facts are one-sided, and they are not the facts that I believe should be in this record. And I don't think we've made a record of those facts. The only record that we have agreed upon in the record that we made is that he didn't stop for the accident, and he had to return to the scene of the original accident when he called 911. So, and Judge,
Okay.
again, go ahead.
So,
I'm sorry, Judge.
I understand that there might be disputed facts, but in order for me to properly sentence, I have to, in my head at least, have some resolution of the facts as they've occurred, or at least how I perceive that they occurred. Otherwise, I just sentence on a charge and forget the rest of it. There are certainly going to be failure to stop and reports that are, an accident that the cars bump each other and one person just leaves, or it's an accident and the person just doesn't report it. They go home. You have those cases. I get it. But this one is very different in terms of what transpired. And what is different in my mind about it is the failure to remain, the failure of Mr. Torres to remain where he was. What then happened?
I don't believe that. Oh, I'm sorry,
Go
Judge.
ahead.
I thought you were asking. I apologize. I did not mean to interrupt.
No, go ahead. Go ahead.
I think, and you may disagree with my answer, but the answer to that is what was going to happen was going to happen, because our version of the facts, what we believe to be what happened is, and I'm trying to walk very fine line here so that I'm not trying to dig into anybody, but the reason that the girls wanted to leave the initial traffic stop is because they didn't want to have the police come, because there were some, they're kids, they were doing some things that kids do, and they didn't want that to be the issue. So when they left the scene at a high rate of speed, the initial accident, they were going to continue to do that because they didn't want to have to go back to that accident scene. Now, that's the nicest way that I can say it. I'm not trying to be rude or to anybody, to the family there, but
No,
they
I
left
get
the
it.
scene because they didn't want to stop.
I get it, counsel, but the problem I'm having here is you're telling me, when I read the report, when I read the rendition of what transpired, I shouldn't take into account things that I see here that give me a bit of pause. Because on the one hand, what you're telling me is that the accident would have happened, or that the rear end collision occurs, these young ladies take off, and that if Mr. Torres does nothing, that this would have occurred. What I read, so that what I just stated is on the one hand. What I read and what I'm seeing is the bump in the rear occurs, and then these young ladies take off, but continue doing what they're doing because Mr. Torres is behind them.
But there's nothing illegal about that.
Otherwise, counsel, and even in terms of just the charge, why the charge really is that he didn't just stay where he was and report it.
That's what the charge is. Yes. The prosecution didn't bring another charge based on the following them. I mean, they withdrew that charge, and there's nothing illegal about following somebody that hit you, to see where you're going, as long as you're not, hitting them and assaulting them. I get that they were probably worried.
All right, I hear what you're saying, but I don't see that here. I'm just going to let you know, that's not what I see.
Can I say something?
Your client wants to speak. Do you have an issue with that, counsel?
Yeah, no, don't say anything at the moment, please. Judge, I think part of the reason that you don't see that there is because you're getting one version of the facts when you look at the police report. The police report doesn't have another version of the facts. Mr. Torres wasn't required to give a version of the facts or to say anything. And there's no other independent evidence. Even the video that they said showed him going at a high rate of speed, that video didn't show anything. There's no speed limit on there whatsoever. It's impossible to tell. But had this been a sentencing about somebody being involved in causing the death of someone else, that would be what the charge is. And I see your difficulty, Judge. It's tough because this is a sad situation, but that's not what he pled to. And had he known that this was going to be a situation where he has to, answer for, why things ended up the way they did, instead of just focusing on the leaving the scene of a property damage accident, he wouldn't have made that plea. I mean, it's a difficult case, and I know the prosecution had some difficulty, taking those charges away, and I'm glad they did, because it just wasn't something that could be proven. But if somebody rear ends you and then they take off and you follow them, there's nothing illegal about that. And if those people choose to run away at a high rate of speed and get in an accident, that shouldn't be the person's fault who chose to follow them. And that person shouldn't have to go to jail because they chose to follow them. I'm sorry, it is an incredibly difficult situation. it's very painful. It hurt my heart to read the police report also. It really did. And I know people may never see that, but it did, because it's a sad situation. But the solution isn't to throw somebody in jail because they chose to follow somebody. There's just no evidence that he was, you know, trying to strike them, or that he hit them, or that he pursued them all the way until the accident. In fact, the evidence is the contrary. It's that they sped away from him, and that he couldn't even see them when he turned his vehicle around. The accident hadn't even happened.
And under your version of this, how far did he follow them?
According to the reports, he turned around on the street well before the railroad tracks, and the oncoming vehicles that passed the truck before it was in the accident did not see Mr. Torres's vehicle on that road. So he turned around before that even, you know, at one of the turnarounds as soon as you get onto that road. According to Mr. Torres, what he said in the report was that he lost sight of them, turned around and called 911, and that's what he told 911. So, and that went along with all of the other vehicles that were coming down the road, was that they didn't even see Mr. Torres pursuing that truck. Nobody saw Mr. Torres recklessly pursuing the truck. Nobody. The only thing that saw is a camera and Mr. Torres's own comment to 911 that he followed them.
Okay, I understand that as you're talking about the idea of recklessness, and I've purposely been avoiding that because of what the charge was and what it's been reduced to. What I'm talking about is something a little bit different. I'm talking about young ladies take off. What happens if he indeed stays where he is? Your version of it, right, we may never know, but your version is the same thing happens. As I look at
the same thing could
this,
happen.
pardon?
So sorry. I'm sorry, Judge. You're correct. My version is the same thing could have happened. Yes.
And when I read through everything, I'm saying, and I'm not trying to attribute necessarily a level of cause, but that something different happened because he continued after that. So
I think in order to,
just so that I can finish that point, that makes this a different kind of failure to stop case in my mind. Because if he had stayed, as I read everything, I don't know that the same thing happened.
I don't think we know that the same thing doesn't happen, though. And that's the thing, is the failure to stop at a property damage accident isn't because they're worried that you're going to take off and chase somebody and have that person get in an accident. It's because they want you to stay behind and to report the fact that there was property damage and that there was an accident. I think what we're doing is we're taking it and we're moving forward with facts that absolutely 100% would have been disputed at preliminary exam and at trial had we known that they were going to be facts that would be considered. And that being the case, Judge, I would have preferred, if these facts were going to be considered, I would have preferred to have an evidentiary hearing on it, or a contested hearing. And that's actually what we initially elected to do before they dismissed the charges. So now those same facts that I initially wanted to contest are being used against Mr. Torres and accepted as true. And I'm not saying you shouldn't be able to do that as the judge. Obviously, you're the decision maker, but that's why we didn't move forward with a plea to anything or with a hearing as to anything, because when we set the case for a hearing on those disputed facts, the prosecution then removed those charges. So everything after this failure to stop at the PD accident, which was a compromise. I suggested that to the prosecutor, who graciously considered it. Everything after that, that's what's in dispute. In my position, judges, it's certainly not fair to consider the evidence as against my client simply for the fact that he chose to plead to something. These are contested facts, and if we're going to have contested facts, respectfully, Judge, I'd ask for an evidentiary hearing on them, or I'd ask that Mr. Torres be allowed to withdraw his plea if we're not allowed to at least contest the facts or put on, to challenge the evidence that the court's relying upon. And I don't think that you're relying upon crazy evidence, Judge. I think you're reading it the same way any reasonable person could read it. But there's also, it could just as easily go the other way. And I don't want Mr. Torres to be put in jail for something that, with a proper hearing and proper evidentiary hearing, is something that I don't believe can be proven. And I think the prosecutor doesn't think it could be proven either, because they're the ones who withdrew that plea or that charge.
Okay, I hear you, but I don't know why, and I don't know that it's up to me to try to figure out why charges get reduced, because there are various reasons why that happens. So I don't know. I don't know what was going through the party's mind. I am telling you how I see this case, but I might see it differently. And so right now and you can appreciate this, I'm reading the report, I'm looking at that, I'm drawing my conclusions from it. I'm hearing you where there's a different conclusion, and because they're typically not at our sentencing, I'm not hearing from the prosecution regarding their side. And then if I hear that, then certainly I can, because it's what I do, I can try to resolve that in my head to see if it makes a difference. I think I'm going to need, to start out with, I'm going to need a prosecutor present. And if it appears that I'm reading it wrong, I'm reading it wrong. But I'm seeing it a particular way right at this moment. But I'm going to need a prosecutor present. I will leave that to you to make the decision as to whether or not you wish to withdraw the plea and send this back up on either the felony charges or something else. But I can't, my intent was to follow the recommendation of probation at least. And I hear what you're saying, that if that's what the court's going to do, you want an opportunity to maybe do something different.
So my main concern, the concern was more about the jail. I've talked to Mr. Torres. I'm sure that he doesn't want probation, but sometimes you get probation with a misdemeanor. So I wasn't concerned about the probation, and I could talk to Mr. Torres about whether he wants to withdraw the plea. And I appreciate the court considering my position as well. I just don't want it to be. I've spoken too much on this, and I'm so sorry to take the court's time. But
no, that's fine. I realize that the mothers, and I'm presuming other family members, are here. So folks, I hope there's an understanding as to what the court is saying, and what I'm about to do. I'm not doing it to cause any more distress or angst on behalf of you folks, as well as I'm not trying to do that in terms of Mr. Torres. I just have to, in my head, be clear in terms of what I'm doing. And none of this is easy, but I hope you can at least appreciate that. And that, because this is a hard case. I'm going to suggest, counsel, that maybe you speak with the prosecutor's office so that maybe there can be some understanding that the court can have. I'm going to adjourn the sentencing, and if you can't, then at least you understand where my head is, at least at this given moment. Then you could maybe file your motion to withdraw the plea or do whatever. I mean, I give everybody the opportunity. I will adjourn this to January 24th, 2024 at 9 a.m. Folks, I said everything at 9, but it's set in a different block and time block, and I'm sure somebody will get to you to let you know where that is. Okay. Any questions?
I personally will be present on that day so that I don't have to rely on somebody else to not show up. And I'm very sorry to your court and to the victims' families for having to wait around.
That's fine. Can we, to the victim's advocate, I guess I'm going to put you on the spot. We can make sure that we have a prosecutor here on that day.
Judge, I can do my best to make that request. It may be a little stronger coming from you.
So you want?
Is there a way for you to request that?
I think the email will go out right now. Okay, who,
I think Morgan.
would it be Morgan? Okay.
Has appeared on, Ms. Reiser has appeared on this case before, so I'm not certain. Maybe if it goes to both.
Both of them. Yeah, okay. Why don't we send it to Ms. Reiser and to Ms. Barossa?
I think Ms. Reiser took over.
Pardon?
I think Ms. Reiser took over for Ms. Kirby when she left.
Yeah. So why don't we send it to Mr. Ganatra, Reiser, Patricia Reiser, and to